If you have a will, does the estate need to go to probate? The answer is it depends. Quite generally, if your estate is worth more than $50,000, then probate will likely be required for your will. Now, $50,000, how do we work that out? It's the assets that are in your sole name or require probate if they are worth more than $50,000. So if you've got $50,000 in a bank account in your sole name and you've got some shares and you've got a car and you've got a house, then you'll probably need probate. But if you are married and you as husband and wife have a house together and that house is joint tenants and you have joint bank accounts, then probate may not be required because the assets are held jointly and there's no need to get probate to release any assets. So it really just depends on how your assets are structured, whether you own them jointly or separately, and the value of your estate. But generally speaking, if your estate's worth more than $50,000, probate would be required for your will. And probate is really just sending the will off to the Supreme Court with an application, and the court is verifying the validity of your will and the interpretation of the will. So making sure that you as the executor are actually interpreting the will and giving the estate to the right people. Once that's done, the court will send you back a grant of probate, which you then provide to the banks, the land registry service, the share brokers to get the shares released, and essentially the banks, share brokers and registries and the land registry service go, okay, great, you are the right executor, you've got a valid will, you're authorised to deal on behalf of the estate as the executor. Now, probate is the term that we use when someone dies with a will. When you die without a will, we don't get probate, we get letters of administration, which is a similar process, but I would say far more complicated and stressful, because dying without a will is just a headache. Please make your will, get it done.